your presence by saying present through the microphone. That is for purposes of accuracy as to the members who are attending the hearing today. Comsec, please.
Thank you, Your Honor. Roll call of the members of the Committee on Justice. Honorable Attorney Jervil Jinky Beatrix R. Luistro.
Present.
Honorable Mauricio G. Dumogan. Honorable Attorney Danilo Dani A. Domingo. Honorable Jennifer A. Lagbas. Honorable Alfredo A. Garbin Jr. Honorable Brian Poe. Honorable Jose C. Alvarez. Honorable Jonathan Keith T. Flores. Honorable Isabel Maria J. Zamora. Honorable Aniela Bianca D. Tolentino. Honorable Laarni Lavin Roque. Honorable Franz Vincent F. Legaspi. Honorable Emilio P. Tanuato III. Honorable King George Leandro Antonio V. Collantes. Honorable Ana York P. Bondoc, MD. Honorable Loreto S. Amante. Honorable Jose Joboy S. Aquino II. Honorable Joel R. Chua. Honorable Ernesto M. Junicio Jr.
Present.
Honorable Arnan C. Panaligan. Honorable Lordan G. Suwan. Honorable Patrick Michael D. Vargas. Honorable Emerson D. Pascual. Honorable Munir M. Arbison. Honorable Janice Degamo. Honorable Bienvenido M. Abante Jr. Honorable Jude A. Asidre. Honorable Bernadette S. Barbers. Honorable Rufus B. Rodriguez.
Present.
Honorable Micaela Angela B. Swansing. Honorable Ramon Rodrigo L. Gutierrez. Honorable Maria Rene Ann Lourdes G. Matibag. Honorable John Attorney J.P. Padiernos. Honorable Terry L. Ridon. Honorable Alan U.T. Honorable Rene Luis M. Co. Honorable Jose Manuel Tadeo Chel I. Diokno.
Present.
Honorable Sara Jane I. Elago.
Present. Sorry, Chair, present.
Honorable Francisco Paulo P. Ortega V.
Present.
Honorable Christopher Sheen P. Gonzalez.
Present, deputized by D.S. Puno.
Honorable Virginel G. Bayron, MD.
Present.
Honorable Yevgeny Vincente B. Emano.
Present.
Honorable David J.J.C. Suarez. Honorable Lawrence R. Defensor.
Present.
Honorable Ivan Howard A. Gintu.
Present.
Honorable Adrian J.C. Advincula.
Present.
Honorable Laila M. De Lima.
Present.
Honorable Percival Percy Sendanya.
Present.
Honorable Antonio L. Tino.
Present.
With a total of 26 members responding to the call, the chair declares the existence of a quorum. We are now officially in session. The committee will now proceed to the reading and approval of the minutes of the meetings held on February 24, March 2, 3, 4, inclusive, and March 11, 2026. For the record, the Secretariat has already distributed copies of the minutes to the members of the Justice Committee. The Chair is now ready to hear the necessary motion to dispense with the reading of the minutes and for its approval.
Madam Chair,
The Honorable De Lima.
I move to dispense with the reading of the minutes of the previous meeting and for its approval.
There is a motion
Second, Madam Chair.
to dispense with and approve, to dispense with the reading of the minutes of the hearing held last February 24, March 2, 3, 4, and March 11, and for the approval of the same. The same has been seconded. Is there any objection? Hearing none, the motion is granted. The chair will address the committee. We are here today for the resumption of the impeachment proceedings against the Vice President. Today's agenda is simple, yet heavy with consequence. We reiterate that we are not here to decide guilt or innocence. Hindi po ito paglilitis. Hindi pa. We are here for one question. Isang tanong lang. May sapat bang batayan para ituloy ang proseso ng impeachment? That is the only question before us today. Are there sufficient grounds to proceed? Sufficient grounds. That is the question. Wala nang iba. Let us be clear. Today is not about judgment. Today is about justification. Hindi tayo huhusga. Titingnan lang natin kung may dahilan para magpatuloy. To recall, this committee began with 4 impeachment complaints. The first was set aside dahil sa posibleng paglabag sa 1-year bar rule. The second was withdrawn, with the complainants opting to support the third complaint, which brings us now to the third and fourth complaints, the Zaballa et al. Complaint and the Cabrera complaint. Both complaints underwent scrutiny. Both were tested. Pinag-usapan ng mabuti, pinagdebatehan ng matindi, sinuri sa bawat anggulo. Every allegation was questioned. Every point was challenged. Every argument was tested. At tandaan po natin, hindi lang ito ilang pahina. These complaints came with voluminous records, pages upon pages, with annexes and supporting documents. Hindi lang binasa, ito ay inaral. And at the end of that long process, both the Zaballa et al. Complaint and the Cabrera complaint were found sufficient in form and substance. At bakit mahalaga iyon? Because the accusations are not trivial. They are serious, they are weighty, they demand answers. Kabilang dito ang mga aligasyon ng banta sa buhay ng presidente at iba pang opisyal, hindi maipaliwanag na yaman, paglabag sa SALN requirements, panunuhol, at maling paggamit ng confidential funds. Kung ganito kabigat ang mga paratang, hindi pwedeng manahimik. Kailangan itong sagutin. Following the rules, the Vice President was furnished copies of the complaints. She was given the opportunity to respond. Iyan po ang due process. Sa proseso, lahat binibigyan ng pagkakataong magpaliwanag. And she responded. She submitted her answer, 15 pages, with 5 annexes, signed by 16 lawyers, 16 na abogado. And this is crucial. Ito lang ang bago sa atin ngayon. Not the impeachment complaints, because those have already been reviewed, debated, and tested. Not the allegations, because those have already been examined in detail. ang reklamo laban sa Vice Presidente na pagdaanan na. Ang sagot ng Vice Presidente, iyan ang bago. So today, we do not go back to square one. We do not repeat what has already been done. Ang susuriin natin ngayon ay ang sagot ng Vice Presidente, ang tugon niya sa reklamo. Which brings us to this moment to determine whether there are sufficient grounds to proceed. So we ask, did the answer clear the air? Did it refute the allegations? Did it address the seriousness of the charges? Because remember, when the accusations are heavy, the answer must be heavier. At ito ang sentro ng ating pag-uusapan ngayon. Hindi na ang reklamo, na pag-usapan na natin yan. Ang sentro ngayon ay ang sagot. Kung mabigat ang paratang, dapat matibay ang paliwanag. So we focus, esteemed colleagues, on the answer, on its clarity, on its sufficiency. At higit sa lahat, kung ito ba ay diretsyong sumagot sa mga paratang, not evasion, not generalities, kundi malinaw at direktang pagsagot sa bawat aligasyon. And at the end of the day, we return to the question, now that the answer is before us, do we still have sufficient grounds to proceed? Did the answer overturn our earlier finding of sufficiency in form and substance? Did it change anything? Did it weaken the case? Pagkatapos nating suruin ang sagot, may sapat pa rin bang batayan para ituloy ang proseso? Because if there is, then we move forward. If there is none, then we do not. Ang hustisya ay hindi minamadali, pero hindi rin pinipigilan. Iyan po ang tungkulin natin ngayon. At sa pagtupad natin sa tungkuling ito, manatili tayong nakatuon sa malinaw na tanong at sa malinaw na batas. Dahil sa huli, kung malinaw ang tanong at malinaw ang batas, dapat malinaw din ang ating paninindigan. I wish to reiterate, our agenda today is the determination of the sufficiency of the grounds for impeachment complaints against Vice President Sara Z. Duterte. In this regard, the committee notes the appearance ad cautelam and consolidated verified answer ad cautelam filed by the respondent, which was received by the committee on March 9, 2026, 4:25 p.m. That is for electronic. And on March 16, 2026, and for electronic filing at 4:30 p.m. The committee further notes the manifestation of waiver to file reply submitted by complainant's Reverend Father Joel Sabalia et al. And complainant Attorney Nathaniel Cabrera. The same were received on March 17, 2026, and on March 18, 2026. Before we proceed, we would like to hear, of course, we wish to place on record that copy of the appearance ad cautelam, notice of appearance, consolidated verified answer ad cautelam, including the manifestation of waiver of the third impeachment complaint, as well as the fourth impeachment complaint, were provided already ahead of our today's hearing to the members of the Justice Committee. With that, esteemed colleagues, we would like to proceed to our deliberation proper, beginning with the position of our endorsers with respect to the sufficiency in ground. May we call first the endorser of the third impeachment complaint, the Zabalya et al. Impeachment complaint.
Thank you, Madam Chair. And before that, this representation as the endorser of the third or Zabalya et al. Complaint wishes to confirm that indeed the complainants filed a manifestation of waiver to file their reply. And it's because after a careful study of the consolidated verified answer ad cautelam, complainants in the Zabalya et al. Impeachment complaint are of the position and concurred in by this representation that the same failed to controvert the material allegations in the complaint. The consolidated verified answer does not specifically address the allegations raised in the complaint. We also note that the answer still harps on the issue of sufficiency in substance, when that very issue has been earlier or already settled by the positive declaration of an overwhelming majority of this committee. The rest of the points raised in the answer evince a confusion between ultimate facts and evidentiary facts. So, since the answer does not specifically traverse the material allegations nor provide a substantive counter version of the facts, there is nothing for the complainants to respond to. And that's why, for these reasons, complainants deemed it unnecessary to file a reply. So that is a confirmation of the manifestation of complainants for waiver to file a reply. Now, the core agenda today is the determination of the sufficiency of the grounds in the complaints. Now, we all know, I just have to read what is reflected or stated in the complaint itself about the 6 grounds. Ground number 1, VP Duterte committed culpable violation of the Constitution and betrayed the public trust by committing plunder and all malversation, graft and corruption and other high crimes in amassing and converting the amount of not less than 500 million pesos from the confidential funds allocated to the Office of the Vice President for the years 2022 and 2023. Ground number 2, VP Duterte committed culpable violation of the Constitution and betrayed the public trust by committing plunder and or malversation, graft and corruption, and other high crimes in amassing and converting the amount of not less than 112,500,000 pesos from the confidential funds allocated to the Department of Education for the year 2023. Ground number 3, VP Duterte committed culpable violation of the Constitution and betrayed public trust by corrupting and bribing officials of the Department of Education. Ground number 4, VP Duterte committed culpable violation of the Constitution, betrayed public trust, and committed high crimes in contracting to murder or assassinate the President, the First Lady, and the former Speaker of the House. Ground number 5, VP Duterte committed culpable violation of the Constitution and betrayed public trust in amassing unexplained wealth and failing to disclose all her properties and interests in properties in her SAL-N in violation of Section 17, Article 11 of the Constitution. And the last ground, ground number 6, VP Duterte committed culpable violation of the Constitution and betrayed the public trust in committing acts of political destabilization and the high crimes of sedition and insurrection. We will please all note that there are 5 constitutional general grounds alleged in the complaint: culpable violation of the Constitution, graft and corruption, bribery, other high crimes, and betrayal of public trust. And you will please also recall that in the discussion on the sufficiency of substance, actually, the matter about the existence of these grounds have been touched already, in addition to the determination of the discussion or the inquiry into the sufficiency in substance of the complaint. So I see no reason why we will have to go through incisively into this alleged grounds, the enumerated grounds in the Sabalia et al. Complaint. But in the first place, as I expressed earlier, the answer did not specifically controvert any of those material allegations. They are deemed admitted. Only a general denial can be said to be can be said to have been interposed. But was there, in fact, an answer to the material allegations? Yung mga tungkol po doon sa pagbanta nga po sa Pangulo at iba pang opisyal, tungkol din po sa malverse ng mga pera, yung hindi pagkaka-explain ng mga confidential funds, anomalous disbursements, yung mga certification ng VP Sara, siya mismang pumirma, yung mga liquidation vouchers, liquidation reports, accomplishment reports, siya mismo ang pumirma. Yung pag-deliver ng perang ito, doon na nakita natin doon sa affidavit as attached to the complaint ni Mr. Ramil Madriaga, kung saan napunta. Hindi ito doon sa mga tamang gamit para sa confidential funds. Walang sagot tungkol doon sa mga notices of suspension, pag-issue ng notices of suspension, notices of disallowance. Wala po yan. Wala silang sagot tungkol doon. Wala ding sagot tungkol doon sa mga envelopes na yon na dinistribute to certain DepEd officials. Nasaan yung mga sagot sa mga tanong na yan? Nasaan ang sagot tungkol sa non-disclosure sa SALENS ng tamang yaman, yung talagang tunay na yaman ng VP Sara? Yun po ang mga tinatawag na mga material allegations. And yun din, ang mga allegations na yan ang nagko-constitute ng mga grounds na binanggit sa complaint, pero walang sagot. So no, it's pointless really to further scrutinize whether indeed there are sufficient grounds, because that has been exhaustively discussed already in relation to the issue of the sufficiency in substance. So I humbly and respectfully submit to this honorable committee. Thank you.
Thank you, Honorable De Lima. Before we proceed, we would like to acknowledge the presence of the Honorable Robert Nazal from BH Party List, and of course, the Honorable JCM Abalos from 4PS Party List, deputized by the Honorable Minority Leader Marcelino C. Libanan. The committee takes note of the endorser's confirmation of the manifestation of waiver to file a reply of the complainant. But may I know, Honorable De Lima, if there are complainants present today to further confirm the manifestation of the waiver of the filing of reply?
Madam Chair. Madam Chair.
The gentleman is recognized.
Congressman Fortes.
The
Madam
Honorable
Chair.
Fortes is recognized.
Yeah, Madam Chair, just a point of inquiry. Considering that answer has been filed, issues has been joined, the answer has been duly signed by counsel of the respondent, VP Sara. Does the rule of the impeachment under the House allow the respondent to be represented at this point of time of the proceedings by their respective counsel?
Reading from the rule, Honorable Fortes, the proceeding before the Justice Committee is for the Justice members only. if indeed the participation of lawyers of the parties are allowed, the same are limited to assisting the respective clients.
Thank you for that clarification, Madam Chair. But in the same way that the Chair is inquiring as to the presence of the complainants who would confirm the waiver, will VP Sara, if she so decides, appear before these proceedings at this point in time, in the same way that complainants will be allowed to confirm?
The proper time for the parties to participate, which includes the complainant, the witnesses, and the respondent, will be the hearing, during the hearing proper. That will happen after the determination of whether or not there's sufficient ground that supports the impeachment complaint. The only reason why we are asking the endorser if there are complainants who are present is because it is provided under the rules that they may file a reply in a period of 3 days from receipt of the answer. The Committee on Justice is in receipt, of course, of the manifestation of the waiver. But since the confirmation was done by the endorser, we will be able to substantiate it more or perhaps confirm it more if there are complainant or perhaps lawyer who can further attest to the manifestation of the waiver of filing of reply.
Thank you very much, Mr. Chair. I raised that inquiry if only to put on record that this committee is fully compliant with the due process requirement as mandated by the rules. Thank you very much.
Honorable Portes. Honorable De Lima.
In response to the query of the Honorable Chair, Madam Chair, as to the presence of the complainants, there are no complainants at today's hearing, at today's proceedings, but they have executed an SPA, Special Power of Attorney, in favor of the law firm of Sapayan, Lim, Alvarez, and Ligutan, or the Saligal Law, and attorney Amando Virgil Ligutan, and or any of the attorneys or lawyers. And attorney Amando Virgil Ligutan is present today to confirm that indeed an SPA was executed in his favor as representative, not really counsel, but representative of the complainants of the Sabalia et al. Complaint.
We value the confirmation of the Honorable De Lima, but for purposes of the record, we would like to take advantage of the presence of the lawyers. So may we call one of the lawyers of the complainant? COMSEC, kindly administer the oath for the confirmation of the manifestation of waiver of the filing of reply. Kindly approach the microphone, Attorney Ligutan.
Good morning. I am Attorney Amando Virgil de Ligutan. I am the representative duly equipped with duly signed and notarized special power of attorney to appear on behalf of the named complainants, Your Honors. So I confirm that this representation...
If I may interrupt, Attorney Ligutan, we are directing the Secretariat to administer the oath first before he makes his confirmation of the filing of the manifestation of waiver.
Yes, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth before this committee?
I do.
You may now proceed, Attorney Ligutan.
All right. So, good morning, Madam Chair. On behalf of the named complainants of the third impeachment complaints, I confirm that we are formally filing our manifestation to file a waiver, to file a reply to the Vice President's answer. The justifications are written in the two-page manifestation that we filed for the sole reason that the Vice President failed through her legal team to refute specifically each and every material allegation in that 98-page complaints. For that reason, the complainants deem it unnecessary to reply to the Vice President's non-answer, Madam Chair.
Thank you, Attorney Ligutan. I just want to place it on record that the participation of Attorney Ligutan in today's hearing is in his capacity as attorney in fact for the purpose of filing and confirming the manifestation of waiver to file a reply. So with that, we place on record that Attorney Ligutan confirmed already the filing of the manifestation of the waiver of reply. The lawyer is now excused from participating in our proceeding.
Thank you so much.
We've heard the position of the endorser of Sabalia et al. Complaint as to the sufficiency in ground of the third impeachment complaint. The floor is now open for comments and manifestations of the justice members.
Madam Chair.
The Honorable Rodriguez.
Yeah, Madam Chair, I have read the consolidated verified answer, and I'd tell them with caution. And certainly, I would express my disappointment with the legal team of the Vice President, who has 16 lawyers who have signed this particular answer. In an answer, the grounds which were averted to in the third complaint, 6 grounds, should have been answered one by one, because there is a finding by the committee of sufficiency in substance of the 6, although I would like to state that of the 6, I find that those with substance sufficiency is the first and the fourth ground. The other 4 are not. But however, since the committee voted for the entire third complaint to be sufficient in substance, it behooves upon the lawyers. I have been, I was a practicing lawyer before, and quite some time, and I have met many of the lawyers of the Vice President. They're very good. However, in this case, there is no answer to the 6 grounds of the third complaint, and also no direct answer to the 5 grounds. There were 8 grounds in the fourth complaint, but the 6 to 8 complaints were found by the committee to just be corroborative to the first to the 5th.
The public trust in committing acts of political destabilization.
Good morning. I am Attorney Amando Virgil D. Ligutan. I am the representative duly equipped with duly signed and notarized special power of attorney to appear on behalf of the named complainants, Your Honors. So I confirm that this representation...
If I may interrupt, Attorney Ligutan, we are directing the Secretariat to administer the oath first before he makes his confirmation of the filing of the manifestation of waiver.
Yes, please
Contact,
raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth before this committee?
I do.
You may now proceed, Attorney Ligutan.
All right. So, good morning, Madam Chair. On behalf of the named complainants of the third impeachment complaints, I confirm that we are formally filing our manifestation to file a waiver, to file a reply to the Vice President's answer. The justifications are written in the 2-page manifestation that we filed for the sole reason that the Vice President failed through her legal team to refute specifically each and every material allegation in that 98-page complaints. For that reason, the complainants deem it unnecessary to reply to the Vice President's non-answer, Madam Chair.
Thank you, Attorney Ligutan. I just want to place it on record that the participation of Attorney Ligutan in today's hearing is in his capacity as attorney-in-fact for the purpose of filing and confirming the manifestation of waiver to file a reply. So with that, we place on record that Attorney Ligutan confirmed already the filing of the manifestation of the waiver of reply. The lawyer is now excused from participating in our proceeding.
Thank you so much.
We've heard the position of the endorser of Sabalia et al. Complaint as to the sufficiency in ground of the third impeachment complaint. The floor is now open for comments and manifestations of the justice members.
Madam Chair.
The Honorable Rodriguez.
Yeah, Madam Chair, I have read the consolidated verified answer, and I'd call them with caution. And certainly, I would express my disappointment with the legal team of the Vice President, who has 16 lawyers who have signed this particular answer. In an answer, the grounds which were averted to in the third complaint, 6 grounds, should have been answered one by one, because there is a finding by the committee of sufficiency in substance of the 6, although I would like to state that of the 6, I find that those with substance sufficiency is the first and the fourth ground. The other 4 are not. But however, since the committee voted for the entire third complaint to be sufficient in substance, it behooves upon the lawyers. I have been, I was a practicing lawyer before, and quite some time, and I have met many of the lawyers of the Vice President. They're very good. However, in this case, there is no answer to the 6 grounds of the third complaint, and also no direct answer to the 5 grounds. There were 8 grounds in the fourth complaint, but the 6 to 8 complaints were found by the committee to just be corroborative to the first to the 5th grounds. In the fourth complaint, I find that the first 2 has sufficiency in substance, that 3 do not. But I, therefore, am surprised that in this particular case, there is no discussion per ground, and therefore would not give us the real answer of the respondent to the 6 and 5 grounds. 6 in the third complaint, 5 in the fourth complaint. However, Mr. Chair, reading this, there is indeed, I'm only interested in the answer on the 125 million confidential funds in 2022 of the Vice President. And there is an answer. This is paragraph 24. This is page 5 of the answer, consolidated answer. For this 125 confidential funds, the only answer of the Vice President is that in its deliberations of the Sabalia and Cabrera complaints, this committee disregarded the petition for review in Sara Z. Duterte versus Nilda B. Plaras, docketed as COA CP number 2024-0194, before the Commission on Audit, COA, Commission proper, notwithstanding that the subject of that appeal is the notice of disallowance involving the same confidential funds that constitute the principal basis of the accusations therein. Significantly, The matter remains pending and unresolved, and any ruling of the COA would, in any event, remain subject to final judicial review of the Supreme Court. A bare answer to definite allegations, ultimate facts in the third complaint and the fourth complaint. So, but this also would, at the same time, provide the committee the obligation to hear the case, to hear the COA on precisely. Because I have heard the Vice President say that Merry Chris Piatos will be explained. The 11 days will be explained of the 125 million. But unfortunately, it's not here. But I would say that there is an answer, but precisely it does not have the facts that would constitute the real answer, so a hearing would be required on this particular matter. There is therefore sufficiency of ground for the ground of the 125 million confidential fund. Next, the next one where there are just two grounds that I'm saying there is sufficiency and substance. The next one is the threat against the President, the First Lady, the Speaker of the House, Martin Romualdez, by the Vice President of the Republic of the Philippines. The only answer here is on page 9, paragraph 53. This is the only thing that would answer those ultimate facts stated in both the third complaint and the fourth complaint. And may I read, therefore, the answer of the respondent to this threat. It says here, the impeachment complaints likewise brazenly accuse the Vice President of entering into a supposed contract to kill. Yet, they fail to present any shred of proof that any such contract ever existed. Instead, complainants rely on exaggerated conclusions dressed up as fact. With very short answer, Madam Chair, this therefore requires, to me, a hearing on this particular issue, which is ground number 4 in the third complaint and ground number 2 in the fourth complaint. So as far as these two, Madam Chair, I find there is sufficient grounds to continue with the hearing of this case. And since the others were not also, Madam Chair, the others were not clearly answered to, ground by ground, then the decision of the committee stands that there is sufficiency and substance in all the 6 grounds under the complaint, the third complaint, and the 5 grounds under the fourth complaint. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. The Honorable Chua.
Thank you, Madam Chair. Madam Chair, I would just like to give my observation with respect to the consolidated verified answer ad cautelam of the respondent, the Honorable Vice President. Madam Chair, this is, the title itself is likewise similar to the previous answer that they filed during the 19th Congress. It was also a verified answer ad cautelam. So meaning to say, they are now questioning the jurisdiction of this committee without rebutting or answering the accusation point by point. Madam Chair, I understand that we have already decided about the jurisdiction. Therefore, I will no longer lay down the premise with respect to this. Now, it is also quite interesting, Madam Chair, and from the reading of paragraph 1, it appears that this consolidated verified answer is somehow or similar to a motion to dismiss. Because if I may read, Madam Chair, what is written under paragraph 1, it provides that, and I quote, no different from the 2025 articles of impeachment filed against respondent before the Senate and declared void ab initio by the Supreme Court in Duterte versus House of Representatives, this impeachment complaint must be dismissed. Under our rules, Madam Chair, this is a prohibited pleading, Madam Chair. So, aside from that, Madam Chair, in addition to what the Honorable Rufus Rodriguez had said, if we will read the verified answer, this is, we will arrive into a conclusion that this is a general denial. Now, under the, Madam Chair, it is well settled principle that under the rules of court, that a denial is not specific simply because it is so qualified by the defendant. A general denial does not become specific by the use of the word specifically. Paragraph 4 of BP Duterte's consolidated verified answer ad cautelam is, in substance, precisely of such nature. More so, nothing in the said answer controverts the allegation raised in the Sabala complaint. And therefore, all allegations, Madam Chair, in the complaint stand as they were never rebutted. And therefore, Madam Chair, I believe that because of this, we need to conduct a hearing. Thank you, Madam Chair.
Again, for the guidance of the justice members, we are not moving backward. We are moving forward. As I have stated in the opening statement, we have discussed thoroughly already the impeachment complaints. What we need to discuss today is the answer, whether that reduces the sufficient ground required to be able to proceed to the hearing proper. The Honorable Ilago is recognized.
Yes, maraming salamat, Madam Chair. At tungkol lang sa usapin ng due process, hindi po ang standards ng mga members ng committee ang tinitignan kung na-violate ba talaga ang due process, kundi ang pagsunod sa rules of procedure ng kapulungan na ito pagdating sa impeachment proceedings. At malinaw sa rules of procedure, pagdating sa impeachment proceedings ng kapulungan na ito, may mga private citizens na nag-file ng verified impeachment complaint at ito ay na-endorso ng members ng House of Representatives. Nasama rin sa order of business, nagkaroon ng referral sa House Committee on Justice. Sa proceedings mismo, nagkaroon ng determination kung sufficient ba in form and in substance ang bawat impeachment complaint. Nailatag din ang jurisdiction ng committee. At si VP Sara naman po ay isang impeachable officer at may ultimate facts na tumutukoy sa grounds na nailahad ng mga complaints. Nakita rin ng mayorya ng members ng Committee on Justice na hindi sufficient in substance ang mga complaints. Ngayon, nabigyan na nga ng pagkakataon si VP Sara Duterte na mag-file ng kanyang reply, ngunit hindi naman niya na-address ang mga grounds doon sa mga nasabing impeachment complaint. Ayan. Kaya, Madam Chair, hayaan nyo na lang na bahagi ko rin sa kapulungan na ito na tayo po ay consistent doon sa sinabi natin na sufficient po in substance yung mga impeachment complaint, ay naniniwala din po tayo na sufficient pagdating sa grounds ito pong third impeachment complaint at sapat po ang batayan para magpatuloy sa hearing ang impeachment complaint laban kay Vice Presidente Sara Duterte. Sa ilalim nga po ng ating konstitusyon, maaaring tanggalin sa pwesto sa pamamagitan ng impeachment ang Presidente, Vice Presidente, Mahistrado ng Supreme Court, members ng Constitutional Commissions at Ombudsman dahil sa culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes o betrayal of public trust. At ayaw ko na nga po sanang ulitin, dahil po sinabi ng ating Madam Chair na hindi tayo babalik dun sa mga napag-usapan na at napag-desisyon na ng mayoryang ng kapulungan na ito. Ngunit talaga naman pong hindi matatawaran yung bigat ng mga accusation hinggil sa maling paggamit ng 500 million pesos sa confidential funds sa ilalim ng OVP at 112.5 million pesos sa ilalim ng DepEd. Higit po na nakakabahala yung paggamit din ng mga peking pangalan at dokumento upang pagtakpan ang korupsyon sa OVP at at DepEd. At ang pondong ito ay mula sa kaban ng bayan at mula sa buwis ng bawat Pilipino, ngunit ginamit ng VP ayon sa kanyang kagustuhan sa tabing ng pagiging confidential nito umano. No? Kaya po, hindi talaga matatawaran yung bigat ng accusations na ito at nakakabahala rin po yung accusation sa pag-hire ng assassin para pumatay. Sa mga maliliit po na tao, nakukulong agad no, sa pagnanakaw ng delata para lang makakain o may pagpatay agad sa mga ordinaryong mamamayan kapag po naaakusahan na sangkot sa gera kontra droga. Pero bakit po sa pangalawa na pinakamataas natin na opisyal sa pamahalaan ay wala pang pananagutan. Ayan. Kaya po sa pangkabuuan, malakas po talaga ang basis para magpatuloy sa impeachment proceedings na ito at matuloy-tuloy po natin ang landas tungo sa pananagutan. Maraming salamat, Madam Chair.
Thank you, Honorable Ilago. Any other member who wish to manifest on the sufficiency in ground of the third impeachment complaint, that is Father Saballa et al. Impeachment complaint? The chair wishes to state for the record that with the waiver of filing of reply of the complainants of the third and fourth impeachment complaint, the complaints and answer are deemed submitted for the purpose of determination of sufficiency in ground. Since the complainants waived already the filing of the reply, we have no reason to anticipate the filing of a rejoinder. It therefore means that the answer of the respondent is the last responsive pleading, which will be included in our consideration in the determination of sufficiency in ground. Any other member who wishes to manifest on the third complaint?
Madam Chair. Madam Chair.
The Honorable Ko.
Thank you, Madam Chair. Madam Chair, gaya po ng ibang mga miyembro ng ating Committee on Justice, ako rin po ay gustong magpahayag ng dismaya no, sa naging developments ng sagot ni VP Sara Duterte. Sa ideal, no, meron pong 2 impeachment complaints na kinakaharap si VP Sara. No, sana po ay nagkaroon ng oras, nagkaroon ng pagdetalye, ng pagsagot no, sa mga bawat paragraph, bawat recital of ultimate fact, no, bawat ground na inaakusahan ng publiko si VP Sara. Sana po naging oportunidad ito para namnamin no, ng House Committee on Justice, yung mga miyembro nito, yung iba't ibang posibleng depensa ni VP Sara Duterte. Yun nga po yung ating mga pinoint out doon sa discussions of sufficiency of substance and form. Hindi ito ang panahon para dito. Kailangan nating bigyan si VP Sara Duterte mismo no, ng kanyang pagkakataon or opportunity to defend herself according to due process. Nalatag po ng ating kinatawan sa Gabriela no, ng kababaihan na we went over and above, no? Dinetalye yung steps by which this due process is provided to the Vice President. And unfortunately, ang pagtingin ng representasyon na ito, she squandered that opportunity. No? Sa simpleng pagbigay ng kanyang response ad cautelam, no, na sinasabi lang niya na ito'y sagot, pero no waiver of all other remedies, pero kung iisa-isahin natin yung kanyang naging content doon sa kanyang answer, they are non-answers. They are continuously pagbalik doon sa, and pag-harp on sa naging proceedings ng sufficiency in form, sufficiency in substance, no? And generally, mga habol sa naging proseso. Ito'y oportunidad sana para ang mga miyembro makapag-take talaga din ng pagkakataon na ma-appreciate yung defense ni VP Sara Duterte. Alas, hindi po ito pwedeng mangyari sa gantong stage. That is why, no, Madam Chair, no, I'd love to also exhaustively, no, provide rebuttals or ang ating pananaw dun sa kanyang mga depensa, no, and in defense of the grounds that we see exist for the proceeding of the impeachment complaint. So, sa kinatawan po na ito, there is basis for us to say there is sufficiency in grounds. Perhaps I can manifest later, no, ano po yung mga grounds na yon. But because, at least for now, no, ang dinedeliberate natin is yung sagot, no, and paano nito ma-i-influensyahan yung pagtingin natin sa sufficiency in grounds. No, kailangan nang magpatuloy sa trial. Or at least kailangan nang magpatuloy sa hearing on probable cause sa level po ng House Committee on Justice. No, magkaroon ng compulsion kay VP Sara and the other witnesses, no, para i-present na yung evidence dito sa harap ng House Committee on Justice. That's all for now, Madam Chair.
Thank you, Honorable Ko. Again, I wish to state for the record that while some members wish to manifest on a per ground basis, just like what the Honorable Rodriguez did, I wish to share to the members that under Section 7, what is being determined is the complaint's sufficiency in ground. In other words, we will be later on voting on the sufficiency in ground of the entire impeachment complaint and not per ground. Nevertheless, the committee welcomes the manifestation on specific ground if that is the desire of the justice members. Any other member who wishes to manifest on the sufficiency in ground of the third impeachment complaint? The Honorable Tino?
Maraming salamat, Madam Chair. Tingin ko maaaring panindigan ng kinatawang ito na sapat at matibay ang mga batayan o ang grounds upang ituloy ang proseso ng impeachment laban kay Vice Presidente Sara Duterte. Particular dito sa third complaint at maging dun sa fourth complaint. No? Unang punto, ipinapahiwatig ng kanyang tugong isinumite ng ad cautelam o with caution ang kanyang plano ngayon pa lang na idiskaril na ang proseso at takasan ng pananagutan sa pamamagitan ng pagtakbong muli sa Korte Suprema. So yun po ang ibig sabihin nun. Kaya nananawagan po tayo hindi lang sa Justice Committee kundi sa House na kailangan panindigan natin ang ating poder, no? Our power as a co-equal branch sa proseso ng impeachment. No? Hindi dapat tayo pumayag na muli na namang madiskaril ng isang desisyon ng Korte Suprema ang impeachment. No? Pangalawang punto, kapansin-pansin ang kawalan ng tahasang pagtanggi sa mga mismong paratang laban kay Vice Presidente. So walang tahasang pagtanggi ang Vice Presidente sa mga aligasyon. Hindi niya kailanman sinabing hindi totoo ang mga akusasyong ito o inilatag kung ano ang tunay na nangyari. Nagtatago lamang siya sa likod ng mga pamimiloso po ng mga abogado at teknikalidad tulad ng kawalan umano ng due process at ang kapusan daw ng ebidensya laban sa kanya. Pilit niyang iginigit na walang ultimate facts ang mga reklamo at wala raw siyang dapat sagutin. Ngunit pinabubulaanan ang pahayag na ito ng mismo sarili niyang mga sagot. No? Nagawa niya for example na talakayin ang mga usapin ng command responsibility, no? Ang kung katanggap-tanggap ba o hindi ang ebidensya at ang maging yung timing ng aksyon. Pinatutunayan lamang nito na malinaw ang mga akusasyon at lubos niyang nauunawaan ang bigat ng mga ito. Isang malaking panlilinlang ang pagdadahilan ng Vice Presidente na dapat munang hintayin ang pinal na desisyon ng Commission on Audit o ng mga korte bago umusad ang impeachment. Pilit niyang binabaluktot ang katangian ng prosesong ito. Mas mataas ang pamantayan ng serbisyo publiko kaysa sa simpleng kawalan ng final judgment mula sa korte. Hindi ang pagiging malaya sa hatol na kriminal ang sukatan para sa mas mataas na posisyon, sa mga pinakamataas na posisyon, kundi ang pananatiling karapat-dapat sa tiwala ng taong bayan o public trust. No? Hindi sapat na sabihin na hindi naman ako convicted, therefore hindi ako dapat ma-impeach. No? High public office demands a higher standard. Kaya nga po isang ground yung for impeachment, yung betrayal of public trust. Sinasalamin ng ganitong palusot ang katangian ng mga umaabuso at nagnanakaw sa pondo ng taong bayan na mga public officials na nagtatago sa likod ng mga batas habang walang awang pinagkakaitan ng batayang serbisyo ang mamamayang Pilipino. Walang batayan ang pag-iyak niya ng kawalan ng due process. Nabigyan siya ng abiso ng komiting ito, binigyan siya ng pagkakataong sumagot at nakapagsumite nga siya ng kanyang panig. Sa kabilang banda, nais po nating irehistro at nagpapahayag tayo rito ng mahigpit na reserbasyon sa pagsama ng mga paratang ng sedition, destabilization at kaugnay both in the third as well as the fourth complaint bilang mga batayan o ground sa reklamong ito. Madalas na ginagamit ng mga nakaraan at ng kasalukuyang Marcos Jr. administration ang mga paratang na ito upang supilin ang lehitimong pagtutol para patahimikin ang mamamayan at gawing sandata, lalo na laban sa mga progresibo at sa tunay na oposisyon. Hindi natin dapat pahintulutan ang pag-abuso sa mga kasong ito para sa pampulitikang panunupil. Pilit ding binababa ng Vice Presidente ang antas ng pagdinig sa pamamagitan ng paghingi ng mga ebidensyang pangkorte sa yugtong ito. Ginagawa ang pagtimbang sa mga testimonya at ebidensya sa formal na paglilitis sa Senado, hindi sa panimulang pagsusuri ng komiting ito. Hindi sapat na dahilan ang kawalan ng court grade evidence upang patayin ang reklamo sa ngayon. No? Tahasang paglapastangan sa mamamayang Pilipino ang paggamit ng ganitong mga taktika upang iwasan ang pananagutan. Umaalingaw-ngaw ang panawagan ng mamamayang Pilipino para sa hustisya. Kinakailangang harapin ng Vice Presidente ang formal na pagliliti sa Senado. Dapat ipagpatuloy ng walang pag-aatubili ang prosesong ito upang mabunyag ang buong katotohanan at mapanagot ang dapat managot. Maraming salamat po.
Thank you, Honorable Tino. The Honorable Nasal.
Thank you, Madam Chair. You mentioned earlier that just a point of clarification, you mentioned earlier that no additional pleadings will be allowed after
It
the
is
hearing.
because the complainants who are given the opportunity to answer the answer,
Yes, ma'am.
that is by way of filing a reply, already waived that opportunity. The subsequent pleading is supposed to be an answer to the reply. We call that rejoinder. Because of the waiver of the filing of the reply, there is no reason anymore to anticipate the filing of rejoinder. And therefore means, it therefore means that the answer filed by the respondent is the last responsive pleading for the purpose of the justice member's determination of sufficiency in ground. The Honorable Nasal.
Yes, ma'am. But after that, ma'am, notwithstanding, pwede pa rin po silang mag-submit ng...
Definitely that will happen during the hearing proper.
Yeah, okay.
For the guidance of the members, the proceeding before the Justice Committee may be summarized into 5 steps. The first step is the determination of sufficiency in form. We are done already with that. Second step is the determination of sufficiency in substance. We are done already with that. Our third step is the filing of responsive pleadings. That includes the answer, the reply, and the rejoinder if there's no waiver of the filing of reply. These pleadings will be used for the purpose of the determination of sufficiency in ground. The next is the fourth step. That is the hearing proper. Notwithstanding the failure of the answer of the respondent to address the specific allegations of offenses and grounds, the respondent can still present their evidence during the hearing proper.
Thank you very much, ma'am.
To complete the steps after the fourth step, when we are done with the presentation of all the evidence and witnesses of both the complainant and the respondent, we proceed to step 5. That is the determination of probable cause, where the justice members will vote by the majority of all the members. This time, this is not a simple majority. This is majority of all the members, which means it includes even those who are not attending the committee hearing. Before I call the Honorable Marcoleta, I wish to acknowledge the Honorable Brian Po, Vice Chairperson, of course, of the Committee on Justice from FPJ Panday Bayanihan Party List. We also acknowledge the Honorable Bernadette S. Barbers from the 2nd District of Surigao del Norte. We acknowledge as well the Honorable Ramon Rodrigo L. Gutierrez, Deputy Majority Leader from One Rider Party List. We acknowledge the Honorable Ana Victoria Veloso Tuason, Deputy Majority Leader. We also acknowledge the Honorable Janice Degamo from the 3rd District of Negros Oriental.
Senior Deputy Speaker.
We thank and acknowledge the presence of our Senior Deputy Speaker, the Honorable Ferdinand L. Hernandez from the 2nd District of South Cotabato. We also acknowledge the presence of the Honorable Julian Jam Baronda, Deputy Majority Leader. We acknowledge as well the Honorable Deputy Speaker, Yaser Alonto Balindong. We also acknowledge Deputy Speaker Janet J. Garin, Deputy Speaker Jefferson F. Conghon, Deputy Minority Leader Honorable Reynolds Michael T. Tan, and Deputy Majority Leader Honorable Hill Cabarangay A. Acosta Jr. To all the justice members and ex-officio members who are here today, thank you for coming. If there are no other, the Honorable Marcoleta is recognized.
Thank you, Madam Chair. I just would like to manifest, since I was Chief of Staff here way back 2004 up to 2024, I've witnessed impeachment proceedings against presidents, one ombudsman, one Chief Justice. Pero wala pa po akong narinig na pag-uusap tungkol sa sufficiency in grounds. Ang naririnig ko lang lagi, sufficiency in form and substance. Ngayon ko lang po yata narinig itong bago na rule na ito, sufficiency in grounds. Could you please clarify me on
For
this?
the satisfaction of the Honorable Marcoleta, please allow the Chair to read Section 7 of the Rules of Impeachment of the House of Representatives adopted by the 20th Congress of the Philippines. Section 7, Submission of Evidence and Memoranda. After receipt of the pleadings, affidavit and counter-affidavits, and relevant documents provided for in Section 6, or the expiration of the time within which they may be filed, the committee shall determine whether the complaint alleges sufficient grounds for impeachment. That is for the satisfaction of the Honorable Marcoleta.
May I know, Madam Chair, when the rules were promulgated?
This
not
has
furnished a
been the
copy.
rules of impeachment of the 19th Congress, which the 20th Congress adopted.
So it's not new. Hindi po siya bago.
This
nga-
has been part of the previous rules, which were used during the past impeachment processes.
Opo, kasi bago lang po sa akin yung sufficiency in grounds. Hindi ko po narinig yan sa mga dating proceedings. Yun lang po. Salamat po.
there are no other manifestations on the third impeachment complaint, then we are calling the endorser of the fourth impeachment complaint to manifest their position on the sufficiency in ground.
Madam Chair,
The Honorable Deputy Speaker Paulo Ortega.
together with my co-endorser, the Honorable Bienvenido Abante, batay naman po sa ating manifestation at waiver po na pinadala, nakikita naman po natin na wala pong direktang mga sagot at puro general allegations, general po na denials lang po yung sagot. At kahit anumang kasunod dito o dagdag ay magkakos lang po ng further delay. So I submit, Madam Chair. Thank you.
We've heard the position of the endorser of Cabrera et al. Complaint. The floor is now open for manifestation of the justice members on the sufficiency in ground of the fourth impeachment complaint.
Madam Chair,
The Honorable Ridon.
na-deliberate na po previously yung ilan po sa mga punto on due process and yung pong kawalan po ng ultimate facts, supposedly. Yan po yung posisyon ng answer ad cautelam ng atin pong pangalawang Pangulo. Hindi ko na po yun uulitin dahil clearly no due process violations had been done against the Vice President. This is precisely her opportunity through this answer to undertake all of these due process mechanisms. Pero she did not avail of it and had in fact submitted what we deem as a non-answer. So yun po yung una on due process. Secondly, on ultimate facts, yung po mga kasama natin kanina, binanggit na ho nila na hindi ho totoo na wala pong pagbanggit ng ultimate facts on confidential funds, on the death threats against the President, the First Lady, and the former House Speaker. Yung po usapin ng salin, all of the documentation, all of the evidence had been submitted by the two complaints. At ito po yung mga papatunayan in each and every step of the proceeding. So hindi po ito totoo na wala pong ultimate facts. But as a final point, Madam Chair, gusto kong banggitin yung binabanggit nila nga double standard ng komite sa papatupad ng atin pong rules on the President's impeachment and on the Vice President's impeachment. Hindi po totoo na meron pong double standard dito. Kasi wala akong pwedeng paghahambing on how the committee had undertaken both impeachment proceedings. Kasi sa una't una, in the President's impeachment, ano ho ba yung laman nung po mga submissions doon po sa impeachment complaint ng particular po ng mga binasurang complaints? Una, karamihan po doon mga news articles lang po yung binabanggit po nila. Pangalawa, meron po doon binabanggit na ebidensya, unauthenticated video document. Ibig sabihin, walang affidavit. Yung po nga submission po nung ebidensya po na yun. But as compared to the Vice President's impeachment complaints, ano yung pinag-uusapan natin ebidensya at dokumentasyon sa bagay po na ito? Una, COA reports relating to the misuse of confidential funds, notice of disallowance, ordering the Office of the Vice President to return ito pong at least 70 million in a supposed misuse of confidential funds. Second, yung pong video documentation of the press conference of the Vice President, kung saan siya po ay nagbanta laban sa Pangulo, First Lady, at dating House Speaker. Video documentation kung saan sinasabi niya na gusto niyang pugutan ng ulo ang Pangulo ng Pilipinas at iba pa hong mga katulad ng mga video documentation. Pangatlo, pagbabanggit po ng Statement of Assets, Liabilities, Net Worth ng atin pong pangalawang Pangulo, kung saan pinag-uusapan po yung paglobo ng kanyang yaman from 7 million in 2007 to 88 million in 2024. Ito po yung mga documentation, ebidensya that exists sa impeachment complaint against the Vice President. And lastly, yung Pumadriaga affidavit, which is something that has been signed and will be tested on credibility as soon as we get to hearing proper. So, Madam Chair, wala hong batayan yung binabanggit po ng answer ad cautelam ng pangalawang Pangulo that the House Committee on Justice had implemented two standards on the President's impeachment and on the Vice President's impeachment. Malinaw po yung standard dito. The standard is based on our rules, on our constitutional mandate, and on the principle of due process and fairness. No? So, tingin ko, the committee should proceed with the determination of sufficiency and grounds, and we have to be able to vote on it today, Madam Chair, and move forward. Maraming salamat po.
Thank you. Any other member who wish to manifest on the fourth impeachment complaint? The Honorable Marcoleta.
Madam Chair, also, again, a manifestation for clarification with the indulgence of the Chair. Akin pong hinihiling ang clarification ng committee kaugnay ng aplikasyon ng Section 7 ng ating rules on impeachment, particular kung kailan eksaktong nagtatransition ng committee mula sa determination of sufficiency and grounds patungo sa conduct of hearings at reception of evidence. Sa malinaw na basa ng Section 7, matapos ang submission ng pleadings, affidavits at relevant documents sa ilalim ng Section 6 o matapos ang lapse ng period, ang tungkulin ng committee ay tukuyin muna kung may sufficient grounds for impeachment. Kung wala, dapat i-dismiss. Kung meron, saka pa lamang magko-conduct ng hearing kung saan papasok ang examination, cross-examination at compulsory processes. Kaya nais ko lamang malinawan, Madam Chair, kung ang mga tinatalakay at tinatanggap na materyales at references sa puntong ito ay para na ba sa determination of sufficiency and grounds o tayo ba ay de facto na nasa hearing stage na dapat ay nangyayari lamang pagkatapos ng ganong determinasyon. Ang paglilinaw na ito ay mahalaga upang matiyak na ang ating proseso ay nananatiling tapat sa ating sariling rules at upang maiwasan ng anumang persepsyon na ang komite ay lumalampas o naghahalo ng mga yugto ng proceedings na malino na pinaghiwalay ng ating rules on impeachment. Maraming salamat po, Madam Chair.
To reiterate, Honorable Marcoleta, the Chair has been stating that we are on the third step. That is the determination of sufficiency in ground. So all these proceedings are towards determining whether or not sufficient ground exists to be able to proceed to this impeachment proceeding. It is only after the declaration of whether or not there is sufficient ground that we may be able to proceed to hearing proper. During the hearing proper, both the complainant and the respondent will be given opportunity to present their witnesses and their evidence.
Madam, di po dapat we should have determined the sufficiency in ground before we voted for sufficiency in form and substance. Kasi we already voted for that.
I wish to direct the Honorable Marcoleta to the rules of impeachment, Secretariat. Perhaps we need to provide him a copy of the rules. Again, the proceeding before the Justice Committee, Honorable Marcoleta, is summarized into 5. And you can confirm this from the rules of impeachment adopted by the 20th Congress. 1 is form, 2 is substance, 3 is ground, 4th is hearing proper, and 5th is the determination of probable cause. After that, we go to the plenary. Kindly look into the copy of the rules of impeachment, because everything that I am saying is strictly consistent with the provision of the rules.
I will go check, Madam Chair. Thank you.
Madam Chair, I encourage all members, even non-members, na sana po basahin po natin yung rules para hindi po tayo nalilito at nang sa ganun po ay maiwasan po natin yung mga tanong na maliwanag naman po sa ating rules, na nakasaad sa rules. Maraming salamat po, Madam Chair.
Madam Chair. Madam Chair.
The Honorable Ko.
Thank you, Madam Chair. Similarly, gaya po ng ating manifestation sa third impeachment complaint, no, paano ba naiimpluwensyahan ng answer or ng sagot ni VP Sara Duterte itong fourth impeachment complaint? Hindi natin masabi dahil wala nga pong sagot na naibigay. No? Pero for the purposes din of the public, no, nakalagay po nga sa rules na merong pong requirement that the committee finds sufficiency in grounds. No? Ano po ba tong mga grounds na maaari nating ilatag at desisyonan, no, para mag-move forward to the next step of the impeachment proceedings sa House Committee on Justice. No? Sa Constitution po, may 6 na grounds, no, na nakalagay. Nandiyan po yung tinatawag nating, may 6 na grounds. No? It is this representation forwarding na sa 6 na nakalagay sa Constitution, VP Sara Duterte is guilty of 5. Mabigat po yun. No? Out of the 6, may 5 batayan to say that guilty po siya. No? Gusto ko lang pong pasadahan, no, bilang appreciation of the body. Una, gaya po ng isinaad natin sa reklamong inendorso ng Makabayan, itinaksil ni VP Sara ang tiwala ng publiko. She betrayed public trust sa pag-abuso niya ng pondo sa mamamayan, sa pangongontrata niya na pumatay, at sa pagsisinungaling niya sa hindi tamang pagdeklara ng kanyang ari-arian sa Statement of Assets and Liabilities o SALN. Para lang pong himayin pa konti, ang pera ng taong bayan na dapat natatamasang benepisyo ng mamamayan ay hindi ginamit ng tama o naiulat man ng maayos ang paggamit nito. May opportunity po sana si VP Sara Duterte to rebut that, but unfortunately in the answer, we don't see it. Hindi lang naman po ito usapin, no, sa kung paano niya na-handle yung confidential and intelligence funds ng Office of the Vice President. Damay din ang pondo ng Department of Education na supposedly nagagamit para sa benepisyo ng kabataan, pero unfortunately ito po ay nagamit para sa katiwalian. Lahat po tayong nagbabayad ng buwis. Paano natin mapagkakatiwalaan na nagagamit ng maayos ang kaban ng bayan kung ang Vice-Presidente ng Pilipinas ay kung saan-saan ginagamit ang perang hiningi niya? Nilabag niya ang tiwala natin na dapat maayos na paggasta ng pera ng bayan. Meron din po na articulation of grounds saying na yung kanyang death threats, no joke, no joke, ito po ay bahagi ng pwedeng sufficient ground for the continuation of the impeachment proceedings. In this representation's opinion, ang kanyang ding pangongontrata ng pagpatay ng sino man, Pangulo man iyan o ordinaryong mamamayan, ay paglabag din sa tiwala ng publiko. Tatak Duterte talaga, like father, like daughter. Pagpapatuloy ng culture of impunity, kung saan tahasang maaari na lang pwedeng sabihin at aaktuhan, no, yung gantong klaseng threat to life, no, to Filipino citizens. Ikalawa, ano pa po yung mga ibang mga grounds as provided in the Constitution? Culpable violation of the Constitution. Pagtahasang may paglabag sa Konstitusyon, maaari pong ma-impeach ang isang opisyales. At para sa atin, no, may responsibilidad si VP Sara Duterte, mga public officials, na magsabi ng totoo sa kanyang SALN, no, sa kanyang mga iba't ibang summons, sa pagdepensa ng spending, but nonetheless, VP Sara Duterte did not do so. Ikatlo, bribery. Siya po ay nanuhol ng pampublikong opisyal in facilitating covert delivery or distribution of cash to influence official functions. Ika-4, meron din pong katiwalian at korupsyon, graft or corruption. She caused undue injury to the government by giving unwarranted benefits through irregular disbursements. At meron din pong lastly, no, other high crimes na ayon sa batas ay mga gawain na krimeng kayang maparusahan sa batas na kung kinasuhan siya ay magiging isang quote-unquote official unworthy to remain in office. Dapat grabe ang bigat ng naging kasalanan na tinamaan mismo ang maayos na paggana ng gobyerno. At pasok po ang kabuuan ng ginawa ni VP Sara Duterte under this definition. No? Samantala, ang representasyon na ito ay may ay critical din no, sa mga argumento na quote-unquote destabilization or sedition. May arguments na nag-articulate na ang kanyang mga naging salita or ang pagpunta sa peace rally even ay nagko-constitute nito. No, sa bahagi po ng representasyon na ito, nakita natin na ginagamit din to against ordinary citizens, against ordinary Filipinos. And we'd like to advise everyone na mag-caution sa paggamit nito, lalo na't ito ay paraan para mag-express din ng grievances ang mga mamamayan. Nonetheless po, sa paglatag po natin, Madam Chair, ng mga grounds under the Constitution, anong acts na pasok doon po sa kanyang grounds, this representation submits that there are sufficient grounds for VP Sara Duterte's impeachment proceedings to continue. Thank you, Madam Chair.
Madam Chairman,
Thank you, Honorable Ko.
may I be recognized?
The Honorable Nonoy Defensor.
Thank you, Madam Chair. Enough has been said this morning, and it bears stressing that part of the due process is to conduct a hearing so that the respondent could also present her evidence formally. And it is also worth stressing that part of due process is expediting an impeachment proceeding. Dapat po mabilis ang isang impeachment process kasi kung walang kasalanan si Vice President Sara Duterte, dapat ma-dismiss na ito at hindi na siya maaabala at makabalik na tayo sa ating trabaho. At dapat mapabilis din dahil kung may kasalanan ang isang respondent, ay dapat mapatrial na ito para madesisyonan ng Senado kung manatili man siya o matanggal sa pwesto. Therefore, Madam Chairman, may I encourage the members of this committee that we proceed with the next step of the chairman in our agenda so we can fruitfully end this day, and whether or not we proceed with the conduct of a hearing, we will determine it as soon as possible. Thank you.
Honorable Defensor, would you like to move that we proceed to voting?
Madam Chair, I move that we decide to declare the third impeachment complaint as having sufficient grounds to conduct a hearing.
Is there any second?
Second.
Second, Madam Chair.
Is there any objection?
Madam Chair.
Hearing none.
Madam Chair,
Are you objecting, Honorable
I
Rodriguez?
am bringing out Section 7. Section 7 precisely provides for determination of sufficiency of grounds, not complaint. While sufficiency in complaint in substance and form, we have to go one by one. I will read now Section 7 because we have to vote on the grounds. And what are these grounds? 6 in the third complaint, 5 in the fourth complaint. Section 7. Submission of evidence and memoranda after receipt of the pleadings, affidavits, and counter-affidavits and relevant documents provided for in Section 6 or the expiration of the time within which they may be filed, the committee shall determine whether the complaint alleges sufficient grounds for impeachment. So we are going to go into grounds because that will be what will be heard in the committee. So I think we should go one by one, so that we will be able to comply sufficient grounds. So I move...
Honorable
the chair.
Rodriguez, I encourage that we revisit the wordings of Section 7 because contrary to the opinion of the Honorable Rodriguez, what is being declared as sufficient or insufficient in ground is the complaint and not the grounds alleged in per complaint. Going back to this provision, it says the committee shall determine whether the complaint, it is the complaint, which is the subject matter of the declaration of the sufficiency in ground, whether the complaint alleges sufficient grounds for impeachment. Earlier, the chair manifested that the committee is welcoming the manifestation per ground. But indeed, if we go back to the provision of the rules, the declaration has to be on the entire impeachment complaint.
Madam Chairman, may
The
I...
Honorable Defensor,
may
there
I-
is a pending motion.
May I reiterate or amend my motion? I move to declare that the third impeachment complaint has sufficient ground or grounds to conduct a hearing by this committee.
There is an amended motion to declare the third impeachment complaint, the Zabalia et al. Impeachment complaint, sufficient in grounds. Do I hear a second?
Second, Madam Chair.
Is there any objection? Hearing none, the motion is approved. The chair declares the third impeachment complaint sufficient in ground.
Madam Chair,
The Honorable Deputy Speaker Janet Garin.
I move to declare and approve the sufficiency of grounds for impeachment of the fourth impeachment complaint, the Cabrera complaint.
There is a motion to declare and approve the sufficiency in ground of the fourth impeachment complaint, that is Cabrera impeachment complaint. Do I hear a second? The same has been seconded. Is there any objection?
Madam Chair, a manifestation.
Is this an objection?
No, it's not. But we'd
Can
like
we
to
first
manifest-
rule on the motion?
We just first manifest that when it's true, it says complaint whether it has sufficient grounds. The adjective sufficient should be the one controlling, that the grounds should be the ones discussed. But I would just like to state that in this fourth impeachment complaint, I find two to be sufficient, the three are not. So that is my manifestation, but I have no objection.
The manifestation of the Honorable Rodriguez is noted by the committee. Hearing no objection, the chair approves the motion. The fourth impeachment complaint is declared sufficient in grounds. At this point, honorable members of the Justice Committee, we declare the conclusion of step 3. We declare the conclusion of the determination of sufficiency in grounds. Now, we proceed to step 4. That is the hearing proper. And in line with that, I wish to add that the evidence and witnesses which will be presented by both parties during the hearing proper will be part of our consideration in the determination of probable cause in our step 5. Having said so, the chair announces the predetermined schedule of our hearing proper. This includes March 25, 2026, April 14, April 22, and April 29, 2026. These are the initial dates for our hearing proper. Likewise, the chair places on record that the committee is in receipt of the approved resolution authorizing, the title of which, authorizing the House Committee on Justice to implement Section 8 of the Rules of Procedure in impeachment proceedings relating to the protection of complainants and witnesses, and further authorizing the committee to continue the conduct of impeachment proceedings and the exercise of ancillary powers during the recess of the House of Representatives from March 21, 2026 to May 3, 2026. This is the authority that was given by the plenary, the House of Representatives, to the Justice Committee to be able to conduct hearing during our break. That explains the predetermined schedule for our hearing proper. In addition, the chair places on record the committee's receipt on March 5, 2026, of the letter of the Honorable Chel Jokno. This is a request for issuance of subpoena duces tecum of pertinent documents. We likewise place on record the receipt on March 17, 2026, of a petition for transfer of custody of witness Ramil Madriaga. Likewise, this is from the Honorable Jose Manuel Tadeo Chel Jokno. The request for issuance of subpoena and the petition for transfer of custody will be acted upon by the committee on the initial stage of our hearing proper on March 25, 2026. Nonetheless, we are directing the committee secretariat to provide copy of the request and the petition to all the justice members. We likewise direct the requesting party, Honorable Chel Jokno, to furnish the respondent copy of the request for issuance of subpoena and copy of petition for transfer of custody. Would you like to manifest?
Yes,
Honorable
Madam Chair.
Jokno?
We will comply with the instructions of the Honorable Chair. At the same time, just for clarification, may I just state that the petition that I filed is for adequate protection under Section 8 of the Rules of Impeachment, which, depending on the discretion of the committee, may perhaps include a transfer of custody.
The chair stands corrected. Kindly reflect the correction that was manifested by the Honorable Jokno. If there are no other matters which the member wish to raise, the chair is ready to hear the necessary motion.
Madam Chair, move to adjourn.
There's a motion to adjourn. The same has been seconded. There is no objection. Kindly amend the motion. Motion to suspend.
Motion to suspend, Madam Chair.
There is an amended motion to suspend. Any second? The same has been seconded. Is there any objection? Hearing none, our hearing is suspended until March 25, 2026 at 10 o'clock in the morning. Hearing is suspended.